God damn it. 0 days. 0 days. 0 days without being muted. 0 days. Where's Josh? Hi, guys. It's Kathy. How are you? So, I hope you guys are doing well. I feel great this morning. It's been 2 weeks, I think. I don't know. I lost track of time, but I feel really good this morning. I'm worried about this week coming up, though. I really am about content because I work every day. We're not even open on Sundays, and I work Sunday, except for Monday. I have off Monday, and I work doubles. So this coming week, the content might be a little shaky because I'm going to try to record while I'm at work, and that's what we're gonna watch the next morning. And I have no idea what we're gonna watch. I won't have time to know. How will I know? So, but guys, don't worry. I'm telling you, I'm working on something big. It's going very, 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 very well, too. So, anyway, what we're going to do today is we're going to watch closing arguments for the murder trial. So that way we hear everything that went on in the trial. And then tomorrow, tomorrow we're going to see a verdict. And let me tell you, it is unanimous. It is not a hung jury. It is not one juror being a pain. It is a unanimous verdict that makes no sense whatsoever and causes complete havoc and chaos and shenanigans. All right. All right, we got to get to the closing arguments, though, to get there. They are each about an hour, which is exactly perfect timing for me, I think.
Good afternoon. I at the very beginning that we have two opportunities to be able to speak to you directly. The opening and the closing. That when we were talking in the opening that the
Oh, my
opening
mic is still on.
is
I
not
thought I muted. I'm so
evidence,
sorry.
right? What we say there is
That was
that
rude.
sometimes we don't know what the evidence is going to be until we're in the trial. And so what we say at the opening is the evidence. What we say in the closing as well is not evidence. It's what we believe the summary of the evidence actually is, or the facts that we want to point out to you for you to be able to consider. But what we say itself is not evidence, and it's just the points that I believe that are important for you to be able to pay attention to during the points of your deliberations. And so, in going through all of that, there are some things that I want to address. Now, you sat here this week and you've heard testimony from the stand. And in going back and forth with that testimony from the stand, we have some contradictions.
Monica, thank you so much for the
And in
cheers.
those contradictions, what I want you to be mindful of on both sides is that memories fade over periods of time. It's just human nature, right? Memories fade over periods of time. And you saw me ask a number of witnesses that very thing. Hey, would you agree that your memory was better closer to the incident date than it is 2+ years later? In most individuals, that's true. I mean, you saw Special Agent Reese. He's the investigator on this case, and he couldn't recall all of the things in the case, and he had to refer to documents. You saw two officers today. One had to look at his body cam and the report yesterday, another one had to look at it on the stand. They had to refresh their recollection. But what do you do when there is no document? What do you do when it is just your pure memory that you are relying on? And so there may be minute differences, all right? Was the sun on the left side or was the sun on the right? That type of minute difference. But what you have to hold on to is, what is the key factor that isn't minute that you should remember if it is true? And so I want to go through this evidence with you, and I'm anxious to get in to this evidence if you cannot tell. I'm anxious to get into it, but there's a few things that I would deem housekeeping that I need to cover with you first so that you can appreciate the evidence when I actually go through it. So the first thing that I want to do is to thank you for being
Kelly,
here.
thank you for the cheers. Thank you.
And, on Monday, some people walked out of here relieved because they're not seated where you are. Other individuals, were disappointed. But this jury service is extremely important. Not just the criminal justice system, but the entire legal system that involves civil litigation. It cannot function without you. It's one of those things where if you want to vote, you got to take this with you. However, our system is unmatched in the world. And you have to realize how important it is that you came here. You showed up when you received that subpoena. You were glad that you were going to get that little paycheck. And you showed up so that you can do your civic duty. And so I want to be the one to be able to thank you for showing up. Now, you put all of your responsibilities to the side. I know you have some things going on there, from work to child care, to caring for family members. You have a number of things that you have going on. You set that to the side and decided that you was going to focus on this case 100%. And in doing that, you agreed that you would try to reach a verdict that speaks the truth in this case. And no matter what that verdict is, it has to be a unanimous verdict. It has to be unanimous, meaning all of you need to agree. And if you're honestly seeking the truth, the hopes are that you all would be able to agree. Now, the other thing is, it has to be your own verdict. Now, I asked questions during jury selection about whether you knew anybody else that was around. It could be your friend, it could be a family member, it could be a distant relative, a co-worker. It doesn't matter who it is. It has to be your own verdict, meaning that you don't vote the way that the person seated next to you or your friend decided to vote. Even if it's at odds in your mind, you vote your way. And if it is your own verdict, then no one would ever be able to change that. Now, you have a tremendous power, and you maybe realize that, maybe you did not. But every time you walked into that courtroom, we were standing for you. The same way that we stand for the judge,
I
we
wasn't
stood
standing.
for you. And that is because you guys are the judges of the facts in this case. It is up to you to determine what the facts are. And that position is so important that we have to give you the deference that you actually deserve for the roles that you have in this case. And just like when the judge enters the courtroom and we stand for him, we stand for you. It is out of respect. And we're giving you that power, and we just want you to make sure that you use that power wisely. Now, we're at Thursday, and we have one more day left in the week. And so I don't want you to get weary. If you get this case at the end of the day and you're saying, I don't want to come back on Friday, let's hurry up and try to reach a verdict without fully considering all of the evidence, then that is possibly a misuse of your power. We want you to use your power wisely because it is a tremendous power that you have been given. And so, it's the end of the week. Endure. Endure. If you need to, endure until you have exercised your oath. Now, when you first were selected as jurors, the judge asked you to be able to stand and you took an oath. And when you took that oath, you promised that you would follow the law in this case. You would be a fair jury and you would base your verdict on what occurred in this courtroom. All of jury selection, we're looking for fair and impartial jurors. We didn't want you to make any decisions until you heard the evidence. And so you took an oath that you would actually do that and that you would actually follow the law. Now, the judge is the giver of the laws. And you're going to take that law, you're going to apply it to the facts that you determine, and that is how you reach your verdict. That's what your verdict is actually based on. So we have these rules that we have to follow. In our community, we have rules. In this courtroom, we have rules as well. But like I said, because you are the judges of the fact, you will look at the rules of law. You would make your determinations of fact based upon the rules of law that the judge gives to you. And then you'll apply those to those facts. And then that application is how you would determine whether my client, Napoleon Flowers, is guilty or not guilty. Now, when I finish speaking today, I'm not going to be able to get up. That's because we have a one argument rule. That one argument rule says that the state has the right to be able to open and close. But as a defense attorney, I only have one shot at it. And because I only have one shot, what I want you to realize is that when the state gets up after me, I'm not going to have the opportunity to be able to get back up and speak. This isn't a situation where we can just go back and forth arguing what the facts are. And so, unless we're going to be here for the next several hours, if not a day, for me to be able to summarize each and everything that was said throughout this trial, there's going to be no way for me to be able to cover everything. I'm picking out my highlights. You guys have yellow notepads, and you have the opportunity to be able to write the notes that was important to you. And collectively, you can share those notes together. It is 12 of you, is only one of me. But you can put those things together, you can get those facts all together and come to your determination that way. For me, only thing I can do is summarize it and not try to be too lengthy in trying to summarize it. Again, just showing you some of the highlights that I want you to key in on when you go back for your deliberations. Now, when the state gets up, she may say something that directly contradicts something that I said. It may go to something that I didn't talk about. It can be something that you would want me to be able to address after hearing her. But again, I cannot get back up and be able to address that for you. I have to trust that the notes that you have, your observations, the demeanor of the witnesses, and everything that you saw in this case, in this courtroom, that you're able to apply that. And I have to trust that my client has to be able to.
I'm glad we did not see more of this lawyer. Sir, point out some facts for this jury to go in there and grab onto. Sir, please.
Trust that. Now, what I want you to realize is that
Don't go back to the beginning. I cough. I forgot to turn my mic off. Don't do it. Skip the beginning.
Indictment that was read to you at the beginning of this case, and which is going to be read to you after the closing arguments have ended, is not evidence in the case. It's not evidence in the case. It's just the way that in our criminal justice system, how we actually institute cases. It's how we bring them. And so you have the indictment and you charge an individual. The indictment itself is not evidence. And it isn't such as, oh, well, you know, Napoleon's been charged, he must have done something. It's just a mere way that we bring criminal charges. And then we go through this process and we arrive to a day like this right now where we are actually able to litigate. And I'll talk about it later on, but the law even says that my client is innocent until he is proven guilty. That means when he walked through this door, he was innocent until he is proven guilty. And so you cannot just say because he is charged that is some form of evidence. Now, the judge again is going to read the indictment to you, and I am going to state some things to you, just in short, as to what the indictment says. Now, there's 13 counts inside of the indictment, and in those 13 counts, there's several different charges, and a total of four different individuals who are named as a victim in the case. Count 1 goes to malice murder, and that is causing the death of Jim Johnson by shooting him with malice aforethought. Count 2 is felony murder by causing the death of Jim Johnson while committing an aggravated assault upon him. Count 3 is aggravated assault by shooting at Jim with a firearm. Count 4 is aggravated battery by maliciously causing bodily injury to Jim Johnson and depriving him of the use of a member of his body by shooting him in the head. Count 5, aggravated assault by shooting a firearm in the vicinity of Tanya Driver. Count 6, aggravated assault by shooting a firearm in the vicinity of Jermaine Deckard. Count 7, aggravated assault by shooting a firearm towards the residence in which Xavier Young was located. Count 8, cruelty to children in the first degree by causing Xavier Young cruel and excessive mental pain by shooting at the home in which he was located. Count 9, possession of a firearm during the commission of a felony, that being having a handgun within arm's reach during the commission of the felony crime of murdering Jim Johnson. Count 10, possession of a firearm during the commission of a felony by having a handgun within arm's reach of committing the felony crime of aggravated assault against Jim Johnson. Count 11, possession of firearm during a felony by having a handgun within arm's reach during the commission of a felony crime of aggravated assault against Tanya Driver. Count 12, possession of a firearm during the commission of a felony by having a firearm within arm's reach during the commission of a felony crime of aggravated assault against Jermaine Deckard.
Don't take off your shoes,
count 13,
please.
Possession of a firearm during the commission of a felony, that being an aggravated assault against Xavier Young. That is essentially a summary of what the indictment actually says. And then for me,
And therein lies part of the verdict problem, guys. Again, the verdict is unanimous on every count they came up with a verdict for, and they came up with a verdict for all the counts. So,
in response to what is in that indictment is, again, my client is innocent until proven guilty. And you have to go through and deliberate and make that determination as to whether he is guilty of the crimes as alleged in the indictment or not. And I tell you, the law does not make it easy to convict a person. And that is on purpose. And that is because we do not want to live in a society where we're just going around and we're locking up individuals and convicting them of crimes that they didn't commit. We make that burden very, very, very high. It's the highest burden at law that we actually have for any type of case. And that is like a suit of armor that covers you. All right, so if you are accused of a crime, you can walk in boldly with that suit of armor, and the state would have to take you out of that suit of armor in order to be able to find you guilty beyond a reasonable doubt. This isn't a situation where they can leave a breastplate somewhere or, maybe a shoulder pad. They have to take you out of that armor. It is protection that you have so that we are not in a society where everyone for everything is being locked up. There has to be a line that is there, and that is why the burden is so high. Brings me to the next term. Burden of proof. Now, I will tell you that trying to define sometimes burden of proof to a person who is not engaged in the law practice can sometimes be difficult. Really trying to understand, some of these things. Beyond a reasonable doubt, it is the same concept. Sometimes it is difficult to be able to define that. But I'm going to make some efforts here to try to be able to do that based upon what the law actually is. Now, burden of proof. When I talked about being in a society and being protected by that suit of armor, that means that the state has to take us out of that. And they have the burden of producing all of the evidence in order for that to actually happen. Even when you raise a defense of self-defense, it shifts. There is a burden that the state still has to go through, even when it is a self-defense claim. That means that I could have come in here, not participated in jury selection, and just said, take whoever, sit at that defense table, not ask any questions of any witnesses, not have to do any cross-examination, not bring up any of my witnesses, and the state still would have had to go through and putting up all of their evidence. And that is because they have the burden. We don't have the burden. We don't have to go out and do anything. And I'll talk about it a little later on, because when we talk about Kayla Davidson, I don't need to go out and find Kayla Davidson. That's not what my job is. That's not what the job of the witnesses are. We don't have to go do that. The state has the burden of proof of choosing what they're going to charge and then following through with presenting all of the evidence that is necessary for that charge. It's their burden. So there is no duty on my client to be able to do anything. And like I said, this applies even to my client's assertion of acting in self-defense. Once it is raised, it is justified as a self-defense, and the state must disprove that beyond a reasonable doubt. And I submit to you that my client's actions were justified, and that the state cannot meet its burden of proof to be able to find him guilty of those charges. Now, trying to define beyond a reasonable doubt, which is the next principle at law. Now, again, it is difficult sometimes to be able to define it, but it is our highest standard at law. It's a term that's often used, and then often at the same time not truly understood. And there is two ways that I'm going to try to be able to explain it. The first way is going to be like this. A reasonable doubt can mean just what it says. It is a doubt of a fair-minded, impartial juror, honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of those. All right? That is what the definition is for a reasonable doubt. And so again, it is.
Oh, I hope he tells us how he makes shoes later in this opening statement. We need a trip to Italy. We need to see mold presses, and I hope.
Isn't something that you can just graze over in the sense of your review of the facts.
This lawyer is
Now,
terrible.
We have to try to establish the truth. If you are a fair-minded, impartial juror, honestly seeking.
Not only that, he doesn't have an accent. We're in Georgia, so we're here for the accent, not really the court.
The truth, we have to establish what that truth is. And when we're doing that, we're going to do that to a reasonable and moral certainty. Reasonable and moral certainty. And I'm sure that at some point, the state's going to, get up and they're going to tell you, you don't have to know this 100%. You don't have to be 100% settled. And I agree. You don't have to be 100% settled. Only thing you need is one reasonable explanation for why you have a doubt. One reasonable explanation. And if you have one, under the law, that tells you that you must acquit. You only need one. You don't need multiple. You only need one reason that you can state a reason for, or one doubt that you can state a reason for, in order to be able to authorize and acquit.
Dodge County, Georgia.
When you look at this evidence, it has to do some things. It has to preclude every reasonable theory except for that which it purports to support. That means, hey, look, there shouldn't be any unwavering. When you look at it, an apple is an apple, an orange is an orange. It precludes every reasonable theory except for that which.
Hey, Josh. 0 days. 0 days without effing up the damn mute button.
It tends to actually support. And it's akin to, I doubt that Napoleon is guilty of this because, hey, I've sat here and I've gone through and heard this evidence. I looked at the demeanor of the witnesses. Napoleon was legally justified in his actions. And how did you get there? Napoleon had not met Jim Johnson before. Napoleon did not make any threats to Tanya Driver on Friday, May the 12th, 2023. Jim Johnson made threats against Mariah and him on Saturday, May the 13th of 2023. And then we get to the incident date of Sunday. On Sunday, May the 14th, 2023, Jim Johnson spoke to Napoleon first. Napoleon's interview, he talks about it. He said, "What's up?" And it was in this tone. He was like, "What do you mean, what's up?" When you heard Tanya Driver testify, she goes, "Hey, they was walking all around. It wasn't an issue until I came out." But then you go back to her first interview, the day of the incident, with Special Agent Reese.
He is,
She
CJ.
said, "No."
He is.
Jim said, "What's up?" Jim initiated the first contact, and that's what started the actual argument. Regardless of what happened on that Saturday, and my client's feelings about what happened on that Saturday, he did not address them. He had been out there. He did not address them. But once Jim started the incident, then here we go. And I'll talk about that a little bit more, as well as some of these other terms. But then you get to this, we're going to do them just like they do us. You hear that on the recording. You heard testimony even today that she calls the police constantly on my client, even though he is at his grandmother's house doing nothing. One example, sitting on the stairs, smoking a cigarette. You call the police. You hear another officer on today talk about Jim Johnson, same street. He calls the police on other neighbors, said that, hey, they flashed a gun. And then flashing that gun, there is an investigation. They find that individuals did not have a gun. Sounds familiar to me. Hey, well, he had a shotgun and he wanted to point it at me. But if you listen to Tanya Driver, when I questioned her about what did the imprint look like, she said that, he flashed a gun, and you can see it. He had his hands in his hoodie. What did he have a hoodie on for anyway? As if there's a prohibition against wearing hoodies. He has a gun in his hoodie. And he stated in his interview, no, it was in my pocket. It was in my pocket. And when I went to the laundry room and came back out with it, it was in my pocket. And I knew they couldn't see it.
No. No, the gun wasn't in my hoodie. No, it was in my pocket. No.
It was in my pocket. So she makes this allegation, just like Jim Johnson did for the other neighbors in the neighborhood. But this time, it just happens to be true. And so when the arguing is there, it's that old adage, sticks and stones may break my bones, but words will never hurt me. The argument is there, and that's fine. But it wasn't until Jim took it to the next level by asking Tanya Driver to go get a shotgun, and then grabbing that shotgun when she came, that my client decided to act. And my favorite out of this entire investigation was the statement that I had read when we started. Don't bullshit me. Because the bullshit was that my client was the only one to be able to say that Jim Johnson had a shotgun. And because he was the only one who said that it must be bullshit.
What? I didn't. So, like, he turned away from the microphone, and I have no idea what his favorite, whatever. I heard bullshit. That's what I heard. But what did he say? I couldn't understand it. Like, when he turned away. This lawyer needs to go.
But then you go through this evidence, and you get a 911 call where you can hear her whisper, put it up, put it up. It was enough to make the investigator go back to the house to find out what she meant by it. And he doesn't get a straight answer. And I feel him, because I didn't get straight answers up here either. We probably could have cut this trial down by a day if we had straight answers. So you hear it on the call, put it up, put it up. Again, I'm going to go through this. It was reasonable for Napoleon to believe that he or the ones that were outside with him would sustain death or serious bodily injury from Jim Johnson firing a shotgun at them if he did not act. And you heard Special Agent Reese in the interview. He didn't have to point the gun in order for you to be able to write a self-defense. His problem was you're the only one who's saying that he had one. That was his issue. No, I'm not talking about you leaving the scene. I'm not talking about, the fact of you shooting them per se. Because if you had one, then that means that you would have had that right. However, you're the only one who is saying that. But again, I'll get to that. Napoleon's actions were justified. Napoleon did not act with malice or any intent to cause pain without justification or excuse. If he was just that pissed off, he could have started shooting right away. He only acted when he felt that it was necessary to stop that force with him and what he thought was his girlfriend, his female cousin and his male cousin behind him. Napoleon didn't have a duty to retreat from any of the actions of Jim Jones. And you heard the prosecutor asking questions, about, who was out there and where everyone was, and, why didn't you do this? You heard Special Agent Reese in the interview asking him, why, if you're going to run after the fact, why didn't you just run to start with? Well, we don't have a duty to retreat. We can stand our ground and defend ourselves or individuals who we think are also in danger. And then Napoleon's actions were not excessive, because I believe that the state's going to try to go there. Hey, well, even if he had a shotgun, you fired too many times. But in the interview, you heard him say, I think I was hitting him, and he still had the shotgun. So Napoleon's actions were not excessive, because Jim Johnson still had that shotgun. He had went around the corner, and he stated, I didn't know if he was going to come back out. That's why he kept firing. The fact that Napoleon is the only one at the Flowers residence to see Tanya Driver giving Jim Johnson the shotgun is not bullshit. Justice heard something about they're going to get a gun. And the state tried to go back and forth with, well, who said it? Did your cousin say it, or did a male in the Driver residence say it? Well, I submit to you, if the statement is going to get a gun, that can only be Mr. Johnson. And the reason being is because he already had his gun. So why would he say something about going to get the gun? When the threats came, he went in that laundry room. He didn't announce that to anybody. He went in that laundry room, he got that gun, he came right back out in his pants. Doesn't need to go get a gun. Then you look at Michaela and Mariah. They went in the house to get Pamela. And you heard Pamela talk about how the house is actually...
It's like trying to walk up a slip and slide uphill with this lawyer. Like, I get some traction with him talking, I understand, and then all of a sudden, I have no idea what he's trying to say. None. And I slide the whole way back down again, and I have to start all over again. So what I know so far, the guy with the gorgeous hair that Bobby loves, Napoleon, got into a beef with the neighbor, heard the neighbors say, I'm going to go get a gun. I'm going to get my gun. So he got a gun. He got his own gun, I think. Right? Is that where we're at? Is that what you guys heard?
Be set up now, that when you come in, she's usually in her bedroom, and if you come in that carport door, you go straight, that's the way to the bedroom. But on the back side of the house, she was in the kitchen, and she wouldn't have heard anybody, coming in. And so when they came in and looked for her, she's in the kitchen. She hears the shot, she goes to the front door, and then they appear behind her. If they all said that they heard Mr. Johnson state to Tanya that she needed to go get a shotgun, that is not bullshit. If you look again at your memories, their story on the main issues are not inconsistent. They haven't changed from the date of the incident. In fact, when we look at Tanya Driver and her statements, they are inconsistent. She gives one story on the date of the incident, but as soon as she's confronted with that 911 call, everything switches up. special agent said he was going to go back and let her see it or listen to it. He never did that. So she stayed in limbo all of this time, from 2023 to 2025. And she just heard it. And when she hears it, now 3 individuals in her household, or at least family members, now all changed. Jermaine Deckard, her son, and hers. All of them changed. And they're changing to be able to fit the scenario of what she built up. She wants you to ignore now the 911 call. And this is saying, well, I was saying a whole bunch of stuff that the 911 call wasn't picking up. How plausible is that? You can hear her whispering some things, but yet you're talking about somebody's at the door and you don't know who it is, and you're trying to, see whether to open up the door or not. And you're asking who is it, and none of that, gets picked up. What you do hear is her say, "That's Jermaine." And that's reasonable. But you also heard him say, "I stepped over Jim on that outer door, and the inner door was wide open." Nobody said anything about touching AR, but all of a sudden the son's story changes, and he's coming down the hall with the AR, and the uncle's taking the AR, and he's putting it on the bed.
Back down at the bottom of the damn slide again. Damn it.
He put it on the bed. But again, I'm getting ahead of myself. It's easy for Tanya Driver and Jermaine to say that Jim did not have a gun. I mean, that's easy. If there wasn't a 911 call, it probably would be a totally different case right now. Just honestly. If there wasn't a 911 call, there would be a totally different case. Because what is the luck of hearing her slip up on that 911 call? So to be able to say, well, yeah, if Napoleon's the only one who said it, then that's easy. And then she tried to cover it up. And if he can describe what the shotgun looks like, the police must have showed it to him. Trying to cover all the bases. But these event facts, they're not adding up. And because the stories of Tanya Driver and Jermaine Deckard are not adding up, you should ask yourself, can I trust anything that they're saying regarding doors being locked? Pick them up versus put it up. How the AR rifle got on the bed. Kayla Davidson being at the house before the police. Video cameras not working or anything else. Even Xavier, even the son's statement has drastically changed. These are drastic. See? So when I talk about lapse of memory over time, those can be the most minute things.
I don't know, Nan.
Did you back into a driveway or did you pull into a driveway? I don't know.
I can confidently answer your question with, I have no idea. He did say those words. AR a couple times with the bullshit thrown in there. And that's when I slid the whole way back down to the very beginning of the slip and slide again, because they were talking about a shotgun, and then they were talking about a gun in his pants, and then all of a sudden there's an AR or multiple, and then I don't know. I have no idea how to answer that question. I think I would have to watch. I need to read what's on the TV screen to know. Because I can't, because the lawyer doesn't tell me. I need one of you to figure out what all that little text is and then summarize. No one can, because it's too blurry. I know that. I do.
In the heat of things. Did the car, pass on the left-hand side of the street or the right-hand side of the street? Well, if we're only concerned about which way they're driving, then that's material. But if we talk about the presence of an individual, doesn't matter. If she was on the left-hand side of the street, right-hand side of the street, she was there. Those are the things that matter. And because there's so many discrepancies here, we have to consider, do I trust anything that you're saying?
What does that say? What does it say? Sergeant John Sandwich next. I read that for you guys, now you know.
No, you don't bullshit me. Special Agent Brees, when I asked him on the stand, if he wouldn't take Tanya Driver's word now. If he would, he's interviewed her multiple times. He's been there. He heard all of the testimony. And when I asked him, would you take her at her word now? I probably wouldn't. And if he wouldn't, as the investigator, then why should you? I have doubts for which I can state a reason. I have doubts for which I can state a reason. We have one of those in this material. That's a doubt for which the law says that you must acquit my client. Plain and simple. So, would you rely on the evidence that the state has presented without hesitation? If you hesitate at all, and you have a reason for that hesitation, then there's a problem. It means you have a reasonable doubt, and that the law says that you must acquit my client. Now, still trying to figure out reasonable doubt. If doubt is such doubt as would cause a reasonable and prudent man in graver and more important affairs of life to pause and hesitate to act upon the truth of the matter. And so, we're talking about important affairs of life. So it isn't like, I was planning to go to restaurant A when I left the house, and I decided to go to restaurant B. Or I decided to get married.
That's the only thing that makes sense, JK. That's his cousin. That's his cousin who usually does. I'm thinking of a good one and nothing's coming to me. Who usually does, not workers' comp, that's too exciting. I need something more businessy. I need a business lawyer name. But just the boring parts of business. Alright, we'll just go with acquisitions. He's an acquisitions lawyer. He's doing this for his cousin. He doesn't really know criminal law or juries. That's all a lie, but that's what I'm going with.
Or I decided to buy a house. Or I decided to take a job. Those are more immaterial because you can change those decisions. You can decide to go to, restaurant B. You can decide to get a divorce. You can decide to sell your house.
And you should decide to get a divorce. Just saying. They are way better than people make them out to be. We need a way to get Jazzy in here. She graduated, right? Jasmine graduated, right? Her school is over. I think she would make a great lawyer. I really do. And I know that she was playing with the idea a little bit. We need to get her in here so that we can guide her to her future of financial aid bills for the rest of her life. But she could be a lawyer.
You can decide to be able to quit your job and go somewhere else.
And buy a food truck. Food
But the
truck.
decision that you make today, you don't get to change. You can't get home and say, well, you know what, I didn't get this time. Or, I had some doubts about this, but I went ahead and went on with everybody else. If you get into a situation like that, and you get home.
Oh, CJ. If it's near breakfast time, means morning, and if I was married, and he brought people over to the house, I'd be a widow in jail. That's not a good thing. That's a horrible thing to do to you. Bringing friends over in the morning. What the heck? I need 7 months notice at least.
Change your mind. There's no way for you to walk that back. So I don't want to over dramatize, the situation, but this is probably one of the more important decisions that you ever have to make. And it is because you cannot change it. And if you think about other things in your life, you can't. You can't change this decision. And because you can't change this decision, it's akin to a situation that I hope that none of us are ever in. And that's if you have a loved one, and that loved one is on life support. And the doctors come to you and they say, look, we've tried everything that we possibly can. You know, there isn't any experimental drugs that are out there. We can't fly them to Switzerland for, some new treatment. There is nothing that we can do. No second opinions, nothing that we can actually do. Our recommendation is to pull the plug.
Pull the plug? Now what? Now I'm back down at the bottom of the slip and slide again. Okay. In my defense, CJ, I've never heard of that. And in my double, triple defense, typos happen all the time in chat. And my eyes have learned to pretend I know what words say when I read a sentence. Most of the time I get it right. But this time I got it way wrong. And that is really good. I would keep him. Being a lawyer, Jude, is outstandingly expensive, even if you do all of the above.
Now, if you can go to the doctor and say, okay, doc, I believe you've done everything that you possibly can. I believe that there isn't, some new technology in the next 5 years that's going to come out that you know about that can save my loved one. I know that, based upon what you're telling me, we can't go across seas and seek treatment. We can't get second opinions. There's no one at Johns Hopkins that can help us out. Yes, doc, I believe you. Go ahead and pull the plug. That means that the doctor has satisfied your mind beyond a reasonable doubt. Because once you pull the plug, you can't go back. Can you pull the plug here? Can you pull the plug here? Can you say that the state has satisfied your mind beyond a reasonable doubt such that you should find my client guilty of the charges in the indictment? And I submit to you, you can't. You can't pull this plug. You cannot. Now, I stated earlier that you only need one. One instance of reasonable doubt that's going towards something that is material. And I say that because it has to be something material, right? Which side of the street a car is on is immaterial in the grand scheme of things. What is material are key facts. Some of those key facts, whether the driver instigated this situation, gave Jim Johnson a gun, and specifically a shotgun, that my client felt justified in firing to be able to protect himself and his family members. That's material. Whether there is a situation of truth in statements, whether there's some cover-up after the fact. And I'm going to try to walk you through it as succinctly as possible and timely as possible. But with
Did you hear? He just said, I hate lawyers. I hate them all.
this credibility is extremely important in this case. Extremely. It's important in every case. But I think even so in this case, it's important because we have a star witness. And that star witness is supposed to be Tanya Driver. That's the person who is controlling this. And my personal feeling that she believes that this is all about her. Because it seems that in all of the testimony, she makes it about her. Just a small instance. Oh, well, I'm an early riser, and I get out there early, and Pamela's out there, and she's harassing me. She already testified about her work hours. The state asked her that. Going to work. Not pulling out my driveway. It got to a point where she said that she wasn't even parking in her driveway, the paved driveway. She was parking in the grass to drive across the grass to a driveway on the other side so that she can avoid confrontation with her neighbor. But her neighbor still made it all about her. That's why there's so many police calls. So witness credibility is extremely important. So what does the law say about witness credibility? A jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including witnesses' manner of testifying, their intelligence, their means of opportunity, of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest.
Sir, you lied a few minutes ago, just so you know. You lied.
In the outcome of the case and their personal credibility as you observe it. And when we're looking at that credibility of witnesses and whether to give their testimony a certain weight, you have to look at whether that witness was impeached. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. And I will tell you that when I look at this statement of law, that Tanya Driver, Jermaine Deckard,
Monica, thank you for the cheers. Thank you.
Have been impeached, that their testimony is unworthy of belief. Is unworthy of belief. And again, we'll go through it. And if you go through all of this, and you go, well, somebody was shot, and Napoleon admitted to actually shooting Jim. He admitted to it. So he must be guilty of something. No. The law says facts and circumstances that merely place upon Napoleon a grave suspicion of the crimes charged, or that merely raise the speculation or conjecture of Napoleon's guilt are not sufficient to authorize a conviction of Napoleon. So, yeah, he admitted that he shot, but he shot in self-defense. And just the mere fact of him shooting does not make it a crime because of how self-defense works. Now, you also notice that my client did not testify. The defendant doesn't have to present any evidence nor testify, and the law says that when that happens, you may not consider that in any way in making your decision. So just like that one argument rule for me where I can't get back up and rebut anything that the state says, my client is under no obligation to take the stand and testify. And that is because the state has the burden of proof, period. They have to prove that. My client doesn't have to prove anything. The state has to prove it. So let's go through it. In the beginning, you had two neighbors who seemed to be able to get along. You heard Mariah talking about, hey, I used to play basketball with Xavier. You heard in the interview Napoleon, yeah, we were cool. But something happened. Pamela even talked about it. Something just happened. Out the blue, something happened. They're on the porch, they're drinking, they're smoking. We know that, at least at some times that marijuana is involved. We found that in the house. Something happened. And things started to go south. And when that happened, that's where the problems actually started to arise. So why did it change? I asked Ms. Pamela if she knew about it. And she says, she doesn't know. For her, it was when she came over out the blue, when she is taking her.
Okay, it's funny because when you said that, I started going through some judges in my head, wondering, like Judge West. I would hate to go up against Judge West if I was a lawyer. But do you think she was prosecution or defense? Judge Manning. Do you think she was prosecution or defense? And I'm going through these judges, and it's hard to imagine them as lawyers. And then my eyes hit the screen, and I see Judge Caulfield up there. Could you imagine going against him if he was a lawyer? I wonder if he was defense or prosecution.
Mother up the steps, trying to get her into the house, and out the blue, Tanya comes over and says, "I hope the old bitch dies." Uncalled for. And Pamela admits, I got in the house, I got my mom up, and I was pissed. I was upset. And I think that that's reasonable, that she's upset. But what do you do with that? What do you do with it? She didn't do anything with it. But yet, you see now this pattern starts with Tanya Driver making it all about her, calling the police on individuals. And then later on, Jim gets involved in the same types of actions. And so we get to Saturday, May the 13th. And then Saturday, May the 13th, what we see at this point is that Pamela gets home from work, and she's going into that laundry room that's at the back of her carport. And when she's going into that laundry room at the back of the carport, that out the blue, there is Jim that is there, and there's Tanya that is there. On her property now, confronting her, out the blue, for no reason, such that it put fear in her, where she scooted around the back side of the carport, around that dryer that's to the left of the back of that carport, to try to get up the steps and get in the door. And she goes in the door. And it's enough that a neighbor witnesses all of this outside and calls Mariah. And Mariah is hot. And you heard Pamela say, she pulled into the driveway and she was parked over on the grass. Now Mariah, she's on the stand and she's trying to remember some of the facts. And you can see the struggle sometimes on her face of some of those more minute details.
Sir, you have been found guilty of murder, but that was your lawyer, so time served.
The main stuff is still there. I pull in, I ain't said nothing to anybody. Jim Johnson is at my car door, wanting me to be able to get out. He's calling me stuff. He's calling my grandmother stuff. He's been threatening to shoot me. And she's getting hot. So much so that her grandmother had to restrain her. It's tense out there. But Pamela remembered those details. Again, you're the judges of credibility. You see demeanor up here. And so she's telling this story. Now, when we talk to Tanya, Tanya is all over the place. First, she's on the porch. Then they're not on the porch. Then she goes, well, we got off the porch because we had to get a little closer because we didn't know who it was, because she just rolled down the window and started yelling at us. But we had a few to drink, maybe 3 beers. And, we didn't go in their yard. We didn't go all the way, to the street. We didn't do all of these things.
Class action, Bobby. We'll all be included.
But when law enforcement gets there, and we had him there today, and again, he handles a bunch of calls. I'm sure.
I should have thought about that before I spoke. You would be filing that against me, wouldn't you? Because I'm providing the content. So the not class action. No, y'all can't get involved. Don't sue me for a yapping attorney.
Report and try to refresh his recollection of what he had inside the report. And he says, it's like, if I had it in the report, then that's what it was at the time of the incident. And so when he goes through, he establishes, look, they're going back and forth, but yeah, as Pamela said, it's like when they start drinking, they get combative and confrontational. All right, that there was threats to be able to shoot, and that he had, and he stated from his own recollection, if you noticed the first time, to be able to say, well, yeah, he said that he had a bunch of guns in the house, but then looked at the statement and said, oh, well, he said they were in the vehicle. But he wanted some.
No, it was in his pocket. Remember, it was in his
and
pocket.
He conducted his investigation. He went next door. There was a teenage youth that was over there. He talked to that teenage youth. And after speaking with that teenage youth, he determined that Tanya and Jim were the aggressors. And what was that commonality that was there?
Yes, CJ?
I didn't even ask her anything about alcohol. Back's totally different. Back's totally different. Her perception is warped. And so that Saturday, May the 13th, it's established that Mariah calls her cousin Napoleon. Napoleon says, don't worry about it. I'm going to be there tonight anyway because we need to wash clothes. She goes and she picks up Napoleon and Michaela, and they spend the night. The next day is now Mother's Day. But I did leave out one important fact. And the reason why these dates are reversed is because that's how the reports actually happen. Once the police come on Saturday, May the 13th, then all of a sudden it's, hey, well, while you're here, the day prior, Napoleon threatened us. So it's a tit for tat, just like she said in that 911 call. Going to do them like they do us. So while the officers are there, it is like, hey, officer, well, I want to make a report myself. Yesterday, their cousin threatened.
The only problem with watching trials with judges you love is judges don't get to talk much during the trial. I love listening to Judge Caulfield or Crawford. I don't know his name. I love when he talks, but I don't get to hear him a lot during this trial, and I want to hear him talking. Look, he's just chill. He's just, yeah, exactly, Bobby. But he's listening. This judge picks up everything. This judge picks up the defendant's facial expressions. This judge picks up what the prosecution is writing down. He sees everybody in the courtroom, what they're doing in the gallery. I'm telling you, I've seen this judge grab a person from the back of the gallery for doing or saying something during the custody trials, and and chew them out. He sees everything. I want to hear him talk.
There's no evidence that he was there, except for Tanya's word, which I'm telling you, you can't believe anything that she says. So there's no evidence that it's there. And if you go, well, maybe he was, well, let's look at some of the factors. Pamela says, yeah, these are my work hours, but I come home to check on my mother. There's a sitter there. Sometimes the kids are there. She talk about, hey, when teenagers watching, they don't want to change her if she soils herself. So she's constantly back and forth. And that last time, she just called in and said, well, I can't come back. Napoleon's not there at any point. But let's think about it. Mariah had to go get him Saturday night. Why? Because his car is down. He doesn't have transportation. He's all the way in Cochran. The Special Agent Reese made a big point about it. You want to take your ass to Cochran. That's where he was on Friday. And so we have this situation where she's trying to make something when there was none. So she goes from that Saturday event to try to backdate it to say, well, something happened to us first. And I'm sure that is to be able to cover any type of interactions that she had. Well, the only reason why we was over here on Saturday is because on Friday he said that to us and we just wanted to talk about it. And she admitted that they went over there for whatever reason. Yeah, we just wanted to talk about it. But if it's such an issue of you calling someone because they're sitting on the steps smoking a cigarette, why the hell didn't you call the police when it's a situation of someone threatening to shoot you? Why wouldn't you do it then? She didn't. And she didn't do it because it didn't happen. So we get to Sunday, May the 12th, 2023. And unfortunately, someone lost their life on this day. So we have the Flowers residence. And what we understand here is that at some point, and fast forwarding through the day, that Justice is sitting down here at the bottom of these steps. And that he is smoking a cigarette because Pamela's already said, I don't allow smoking in my house. He's out there smoking a cigarette and he's in his phone. He knows, gist of something happening the day prior, but he doesn't know all of the details, actually what happened. They're not sitting around talking about it. Otherwise, I would submit to you, he would know. So he's sitting there. Michaela's out there, Mariah is out there, and Napoleon is in that laundry room. That's on that far back side where you see this door open. And they alert him, hey, that's the guy. Why did they need to alert him? Because he didn't know who Jim Johnson was. And apparently, he's been in the neighborhood for a good little minute. But he didn't know who he was. That tells you how often he had been going over there around that time. So he comes out and he sees the guy. As much as he wanted to confront him, he said that he didn't. But the guy said, what's up? And I see that term, if I read it on a sheet of paper, I could take that term several different ways. What's up? Condescendingly, look up and down, what's up? Like what you want to do. You can take that tone so many different ways. And he said he took it the wrong way. He said, what you mean, what's up? And the arguing starts, back and forth. Again, we're 2+ years away. And I even give Tanya Driver and Jermaine, some credit here. In the sense of being able to say, well, there was a lot going on. It was just a lot of, arguing back and forth. I can't remember all of those words that was being said back and forth. I mean, think about your own experiences. Can you remember exactly what was said, several years ago? They were just going back and forth. And that's fine. Sticks and stones may break my bones, but words never hurt me. But where the difference comes in is when Jim says that he's going to get a firearm. That's where the difference comes in. Because at that point, that alerts everybody that this is going to a totally different level. This is no longer words. We're getting into sticks and stones now. And so he goes to the laundry room, he retrieves his firearm that is in the laundry room where he had his other stuff, and now there's a confrontation. Again, they don't know that he has a firearm, but they make that allegation. She calls 911, and we find out some things at that point, but then we got not get too far ahead. So we have the scene that's out here. And then we see they drive her home. And when we're looking at that, there's been some alterations there. There is no seating that is out there now, as if, no one was seated out there. And if you recall, on that Saturday when the police said, well, you had some cameras out there. Cameras pick up anything? Nah, I mean, we were sitting outside, so we had a fan, so we disconnected the camera. Well, we showed that the camera was working on that day. It was working. And we don't see any chairs out there.
So they told Judge Crawford that they were each going to take 1 hour. And this guy freaking lied. Because he has been over an hour.
And so if she had been out there, then maybe she would have disconnected it if you saw chairs and the fan. But you don't see that out there. The camera was working. And we don't see anything disconnected. We don't know there was what was in their cup. But we also don't know what was in their system either. Because no toxicology was requested when they conducted the autopsy. We found that out by the medical examiner. Had very little questions for it. I went right to it. Is there a toxicology report? Nobody asked for one. If there had been one, imagine what we would have found inside of it. So there's no toxicology report, but we know that this was inside the house. Jermaine said, oh, no, it was too early. We didn't start drinking yet. We don't know. We don't know. But we know what there's a tendency to do. So then we get around to the side of the house. And now we start to look at angles. And you heard the crime scene analyst, and again, pleasure to be her first one to be qualified as an expert. But still, you have to do your job. And in looking at this, she marks things down, and she tries to look at trajectories, but she doesn't use any apparatus to be able to make those determinations of trajectories, because she says, well, you don't have to use it. But at least, if we're using common sense, we're looking at angles. If Justice is seated on the bottom step there, if he turns his head left, he's looking at the rear driver's side of that truck. He wouldn't see anything. And he said that. And then we look at where the stairs are. I asked Pamela whether there was a window in that door. You're standing in this yard, you can't even see that door. And so they wouldn't have been able to see what was going on out there, even if there was period at the door. But both of them said, it's like, hey, shotgun, those are magic words. I got up, went and got my grandmother. Or at least attempted to. So both of them run inside. Mariah first, Michaela second. But while all of this is taking place, we get to what I believe is probably the key piece in the case that sheds more light on what everybody's duties, responsibilities, and actions were. So we looked at the angles. No one would have that angle except for Nicole. It's not bullshit. We look at, the opportunities. Well, if Napoleon really wanted to do something, and it was based upon what happened before, or based upon any of the numerous other times that the police were called on him, could have acted a long time ago. So why would he choose to do it now, but for the fact of Mr. Johnson having that shotgun? Then they talk about the number of shots. Well, if someone who I believe I need to use deadly force against has a shotgun, and I'm shooting at them, and they still have that shotgun, what's to stop them from stopping, pointing, and shooting me? So why stop? What's reasonable? So they make a big deal of trying to say, well, he emptied the clip. He shot X amount of times. Well, he said in his interview, I felt like I was missing him. At one point, he did this awkward turn, but he still had the firearm. Then the state tries to slip in here a video and says, oh, well, he had a cell phone in his hand. And, you know, he couldn't hold a shotgun and a cell phone. But nobody testified that he actually had the cell phone in his hand during this incident. And you have a body that is on the ground, and there is an object that is there. And just honestly, I don't know how he had anything in his hand. We hear pick him up, but nobody says that they moved him. But I submit to you that shotgun was moved. Was it gripped in his hand? Was it just laying on his hand? Did it fall out of his shirt pocket? We don't know. Nobody has testified to that, but they want you to look at the video and say, oh, look there, and ignore this over here. So when Jim is struck, he makes this awkward turn, and you heard the medical examiner say, even being shot in the head, you can still function sometimes very briefly. So he may have been able to get a few steps off. And maybe that's what my client saw, because he kept moving. And he said he went in, and he didn't know if he was going to come out, and he booked it. And even when being interviewed, he didn't even know that he hit him, because he kept moving. So why run? He admitted that was probably the stupidest thing that he did. That's the only thing that he thinks that he did wrong. But Special Agent B said the same thing about that. I mean, not really concerned about that. He tried to say, well, you ran because you felt guilty. Like you did something wrong. He said, no, it's like in the heat of that flight. I was trying to get away because I didn't know if he was going to come out the front or whatever. I'm trying to, still protect these individuals because now I done shot at him. So if he has retribution, it's going to be against me. And so he runs. And when he talks to family members, he goes, no, I shouldn't have done that. But by that time, it's too late. But you saw the video. Both of them, extremely compliant. And I asked the patrol officer. And he almost looked shocked like, well, I wasn't expecting this. That all by myself, I'm going to take the two of y'all out of the vehicle, get y'all down on the ground, and y'all going to be so compliant? So yeah, he didn't stay on the scene, but that doesn't negate anything. And he's not charged with anything with leaving. He was compliant. So, we have this view of what are the facts. And as I stated earlier, it's easy for Tanya and Jermaine to be able to say that Jim did not have a shotgun, because who could contradict that except for the person who actually shot? So we say, yeah, he didn't, that's 2 against 1. But then we had the 911. Let me see if I have this queued up.
$14, 2023, 12, 47, 49.
We don't do the shit just like they do us. We don't do them just like they do us. 911. This boy out here with a gun. This boy Napoleon Flowers at 55, 35, whatever he told to me, pulls out a gun, and he ain't even supposed to be 100 feet around me. And they, oh yeah. So
what's the address?
Mine is 5533 Forest Avenue.
Okay, where's he at right now?
Huh?
Where? Shots are fired. Ma'am.
Yes.
What is he shooting at?
He shot him. He shot Jim. Jim Johnson.
He just shot up Jim Johnson.
Oh, my God.
Where's he at now? Where's Napoleon?
We need an ambulance.
Yes, ma'am. Yes, ma'am. We're getting him dispatched. Where's Napoleon at now?
Oh, he went out the back way. I think I was shot, too.
Do you think you've been hit?
I think that's Jermaine right there. Is that Jermaine?
Where did he shoot him at?
Come on. He got hit bad. Yeah, I know. We didn't. We got the police coming.
Okay, where did Jim get hit at?
Huh? Oh, my God. He's not moving. He's not breathing. Jim, just stay with us. Just stay with us. Just stay with us.
Okay, where did he shoot him at?
He done shot him all over his body. He done fell down. It looked like he could be shot in the head. Put it up. Put it up. Put it up. He shot in the head. Oh, my God.
Okay, just stay on the phone. Have you been hit?
I'm hurting, but I'm panicking.
Yes, sir. Listen to me. You have to calm down for me, okay? I don't need you to panic right now because we've got to get Mr. Jim some help, okay? Can you look and see if you have been hit anywhere?
Huh?
Can you look to see if you've been hit anywhere?
He's hit in the head. He's hit in the head.
Yes, ma'am. I know that he's been shot in the head. Have you been shot?
No, my foot may be grazed. Oh, gosh.
Okay, what was Napoleon wearing when he left?
A hoodie. What he had on? It was Napoleon. His girlfriend was boosting it up.
Were they driving?
They jumped in the car and left.
What kind of car?
I don't know. I wasn't looking. We got the camera though. We can pull it up on video.
Okay. Who's his girlfriend?
I don't know her name. Dark skinned girl, dreads, glasses. Today she's wearing glasses.
Okay.
You gotta stay with us, baby. Stay with us, baby.
All right. Is he able? Are you're talking to him? Is he? He's still unresponsive. Okay. All right. I've got everybody coming. Okay. Okay.
Oh, God.
Did Napoleon leave with the gun?
Yes. He emptied the whole round. He emptied the whole clip.
Okay.
It was him, his girlfriend, some more kids, teenagers.
Okay. Can you tell me what the hoodie looked like that Napoleon was wearing?
What color Pole had on? What color? It was a blue hoodie.
It was a blue hoodie?
If I get off the phone with you, I could pull some video maybe. I don't know.
Yes, sir. I'm trying to get all the information I can for my officers so they can try to find Napoleon also. Do you know where he lives?
They say, I think the girlfriend has an apartment in Cochran, but they keep telling the police they stay over here. But
you don't know where?
Huh?
Do you know where at?
That's Pam King grandson. That's Pam King grandson. Oh, God.
Okay. All right.
Oh, God.
Okay, all right. I've got everybody on the way to you, okay? If he comes back, you call me back and let me know, okay?
All right.
All right.
We have moving pieces now because we hear that 911 call, the put it up. And what possibly cannot refer to. Well, when she spoke with Special Agent Reese, she stated, not sure what I was talking about there, but he testified that it was like maybe pick it up. Then I asked him about whether she had said anything about she don't think anyone grabbed one. And I was like, well, what was that one? What do you think that one was? Because she never said what that one was. firearm. But she had to think about that. I don't think anybody grabbed one. But then 2 years later, she's on the stand saying, oh no, my son grabbed the AR. But then, if you notice, I asked her, when did you hear the 911 call? A couple of months ago. So it's more recent now. Special Agent Reese had went back and allowed her to be able to hear that interview. It would have been a different story right then. She already started to invent one, not knowing exactly what she said in that 911 call, because wisely, he didn't play it for her. But now she's trying to make the pieces fit. So we see these two items, and she starts to question, well, that looks older than what it is and whole lot, but then, to see, look, hey, these are my two guns. But then I'm asking everybody, well, how did the guns get out on the bed? Special Agent Reese went to the house and had two questions. How did the guns get on the bed? One, and then two, what were you saying on that 911 tape? How did the guns get out on the bed? Now we don't have clear answers. And remember, I talked about minute details. Minute details, look, if someone can't remember that, it's no harm, no foul. But when we're talking about something serious, like there was a shooting, and whether somebody in your house came down the hall, if you couldn't remember less than 30 days after the incident, then how are you now remembering that 2+ years later? So Jermaine says that he sees his nephew with it, he takes it from the nephew, he goes in. I asked Jermaine, whether anybody told him to do it. No. But then we go back to this, put it up. Explain it. We still don't know what it is. And that's why I said I can feel his frustration because I felt it up here. I just let her talk. And so then I asked about the shotgun. Nobody wanted to talk about the shotgun. Well, what was the shotgun? Who got the shotgun? Nobody wants to claim the shotgun. And I don't know if it's a situation where they thought maybe there was something on it, and now they need to be at arm's length. I don't know. But nobody wanted to talk about how the shotgun got out on the bed. And she went so far as to say, well, I think law enforcement did it, because it would just lay it out like that. Well, it's not law enforcement, because less than a month after this incident, in an in-camera interview, meaning outside the presence of Ms. Driver, Special Agent Reese sat down with her son and said, hey, just square with you. And he reported back that Young said he was in his room. He was playing his games. He heard the shots. He got up. He went across the hall to his mother's room, got the weapons out, laid them on the bed, went back into his room, and called his brother-in-law. And then he stayed in that room until law enforcement said that he could come out. But you heard how long that 911 call was. Kylie Flowers said that she lives around the corner. She was there in 2 minutes. And she was there before the police were. She had enough time to be able to get out of the car, get her son to start walking down the street, to get him away from everything that was going on. And then, at that point, she sees Kayla Davidson. But again, I'm getting ahead of myself.
How can you be ahead of yourself, sir? You've been talking for an hour and a half. You were supposed to do this in an hour. Guys, this stream's going to go extra long today.
We don't know how it got out on the bed because the story that we thought was settled of how they got on the bed now is up in the air from the witness stand. But then we have weapons that was in the closet, and unfortunately the way I'm doing this now, I can't zoom in for you. But I zoomed in for you during the trial. That regardless of whether that's a BB gun or not, that's a pretty intimidating looking weapon. and it was a big thing in an interview with Napoleon as to was it a shotgun or not. And he goes, it's like, look, hey, you're twisting me back and forth. I thought it was a shotgun. Why do you think it was a shotgun? Well, someone tells me that they're going to get a shotgun and they come back with something that looks like a shotgun, then I believe it's a shotgun. But if you're telling me, it wasn't a shotgun, then maybe it was some other type of gun. But it was something that looked like a gun. And would it be reasonable for you to act? Even if it wasn't a shotgun, would it be reasonable for you to be able to act? But they talked about, hey, they tested these, that they were, some of the items were dusty, that these were in the back of the house and the whole line. But again, we get back to Kylie Davidson. You have this one that is in the room with Ms. Driver's son. Now, that looks pretty realistic to me. Even if it's a CO2 cartridge gun. So we get these discrepancies. She's saying, hey, I locked the doors, and we heard knocking, and I kept saying, who is it? Who is it? Who is it? And they wasn't answering. Who is it? I just played the 911 for you. You didn't hear any of that. She whispered, put it up, and I got picked up on 911. So don't you think if she was saying that it would have? That's because she's still trying to justify
You already said this, sir.
that statement.
We've already heard this.
She did not know what the special agent had. So she had to come up with something. And when she listened to it and reconciled it, she had to try to double down on it and get everybody else in the mix with it. Who had the AR? Got conflicting, statements about that of who put it on the bed. And so we talk about this camera in the front. And look, regardless of whether a camera in the back was working or not, and Special Agent Reese says that, he looked up and, it was disconnected. And we may be able to just, assume, based upon that, yeah, the camera in the back wasn't working. But bona fide, we zoomed in. We seen the green light on that camera in the front. And in that camera, if we're looking at it, and it's recording, and it only records motion, we don't know any of that. And I asked him point blank, after hearing everything that she said,
Point blank, period.
would you take her at her word that the cameras just wasn't working? You made a special trip all the way back to ask about these cameras, and rather than seeing anything, she go, oh yeah, they didn't pick up anything. And he said, okay, good enough for me. And left. But now, I won't take her at her word. Well, it's a little late in the game now. We shouldn't have took her at her word back then. Because if what the Flowers have testified to is true, then we have this whole issue here now. You have the testimony that for Pam, that she is out on the front right afterwards, and she looks out and she sees her pulling up. And the police haven't got there yet. Kylie is around the corner. She gets there before the police do. She's able to get out and do some other things before the police actually got there. But she also sees her. Mariah, she sees her. And none of them think anything about it at the time, other than, hey, she's there, all the time, and she's there. It only becomes an issue now that we're in this case. The law enforcement didn't come back and try to do any follow-up with them. No. The only follow-up with anybody was with Tanya Driver. That's it. There wasn't even any follow-up with her son, because the statement less than a month later, was the first statement. Because apparently, she was there before the police, she left, she came back, and got zapped. And so, we look at what was she there for to start with. And part of the issue that I have with this is just how weird it sounds. Because it sounds like a conspiracy theory.
I missed a talking to. Darn it.
If I'm sitting in your position, that could be the thought. But you have to wonder, you have 3 individuals who are here who say she arrived, they saw her, or at least 2 of them saw her walk out with Tanya Driver, go to the car, and then she left before the police were there. Now, if there was a shooting, you go, well, how did she get that fast? Xavier is in the room. He ran across, guns out, back in his room, called brother-in-law. I asked who was her to her family. I asked Tanya that. It's my daughter's best friend. And you heard Pamela say that she's there all the time. So she gets there quick, fast, and her, and gets them. Whether it was the weapon that Jim was actually holding, the shotgun that Jim was actually holding, I don't know. We would never know. But the issue is that causes reasonable doubt. Because what other reason would there be for her to show up as quick as she did in the midst of all of this, for Tanya to walk to the car with her, as close as she did, and then for her to go back in the house and then deny that she was actually ever there before the police? And remember when I asked questions? I asked, hey, do you know Kayla Davidson? Was she there at some point? She wasn't there before the police were. Well, I never asked you that. But you offered it up. So now that you've said that, let's talk about it. Why did you specifically say she wasn't there before the police were? Only thing I asked is, was she there? She made that distinction because she knew it was coming. She knew it was coming. Jermaine, same thing. They anticipated where their issues were, and as soon as I asked anything that was close to it, they were ready to try to defend it. But why I go there? Special Agent Reese, put it up. Well, I don't think anyone grabbed one. Why'd you go there? I didn't go there, so why are you going there? Those telltales. Hey, front camera don't work. Big deal. Shooting in the back. But if she's making this exchange, camera would pick that up. So again, real convenient. Not working. Just like that Saturday. You're the aggressors in this situation. Police ask you about it. Cameras don't work. I unplugged it. What can you do? There's no evidence against me that I'm going to give to you. That's what we want. And look how that camera is angled. Would have caught it. It would have caught it. And then we have these spots here. And I asked the medical examiner about it. Because that sure looks like prints to me. Red prints. Well, you went through and you're trying to mark all of this evidence down. You taking pictures of the door latch and you have no questions about this? And if someone's taking that shotgun from Jim's body and going out that front door, that's certainly a possibility that you're going to leave some prints on a white door sill. So justification, self-defense. Sometimes the defendant's threat or use of force is legally justified and so is not a crime. The defendant is justified in threatening or using force that is intended or likely to cause death or serious bodily injury when he reasonably believes that the use of force is necessary or to prevent death or serious bodily injury to himself or a third person. And actually, let me take this one back. He reasonably believes that the use of force is necessary. For a defendant's threat or use of force to be justified, the defendant must believe that his threat or use of force is necessary. That belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary, and the defendant's reasonable belief must be what prompts him to threaten or use force. So there have to be some conditions there, right? Sticks and stones. You can't start the fight and then say, hey, self-defense, I shot you. No. What the evidence is that Jim initiated this contact. It was all verbal. He escalated it to the next level. The statements of one witness don't need to be corroborated. They just don't. He by himself can establish the fact that Jim had a shotgun. It does not need to be corroborated. And once he saw that he felt that it was necessary for him to use that force because he still had that shotgun. Several times in that interview, he was going to put it in action. I mean, he took a couple steps in it like he was going to use it. It was coming 3 times, at least, in that interview. Took 1 or 2 steps. He was going to do something. That's one of the quotes. He took 1 or 2 steps, he was going to do something. So the thought is, I got people behind me, and I think that I need to use deadly force. Especially Agent Reese. You got to shoot to have self-defense. She didn't care about him leaving. The issue is, Napoleon's the only one saying that Jim Johnson had a shotgun. And I submit to you that through that 911 tape, all of the changes in testimony about the AR and all of the actions that happened immediately after the shooting should cause reasonable doubt in your mind as to whether they were telling the truth and establishing that my client was not giving bullshit. And then there's no duty to retreat. Person who's not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. He didn't start this. He didn't make the first words. Yeah, he engaged in that conversation. And he went back and forth. But he wasn't the aggressor. He stayed in his yard. They went and got a shotgun. They didn't know he had a handgun. He had no duty to retreat. And understanding again, somebody lost their life. And that's the sad part. Somebody lost their life. But you are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. It's not your job to try to get some type of justice or agreement just because you feel sorry that somebody lost their life. You have to base things on what the facts are objectively.
Now we have decisions to make, guys. The prosecutor didn't even start their closing yet. So, I think we should end today on his, or we're going to be here for hours, and then we got to do OJ. Yeah, I think we're going to have to push everything back a day. We're going to end with his. That's a 2-hour stream. That's good. Start OJ normally. And then tomorrow we'll hear the prosecution. We might have time to hear the verdict tomorrow still. The crazy verdict doesn't take hours and hours and hours. I cut all that out. We're going to hear the verdict, and the fiasco that it causes, and everything they do to fix the fiasco, and then the ending. I don't know if he's actually finished. I see only one word on the screen, maybe two, maybe seven, I don't freaking know. But it's not filled with text, so I'm thinking he's getting to the end. And he took 2 hours instead of 1. Jerk. But that's fine. We'll see the prosecution tomorrow.
There's a recap. And I know I kept jumping ahead of myself, so I believe that you got it at this point. I'm just going to flash it. We have our 1 through 4s. What about 5, 6, and 7? And again, these are the ones I showed you earlier. What about 8, 9, 10, 11, and 12? Our 13. Our 14. Our 15.
I do that sometimes, Bobby.
My favorite. 16. So if Reese wouldn't believe it, why should you? I want to remind you about that one argument rule. I can't get back up. I spent some time here, maybe a little longer than I had originally anticipated, wanting to make sure that I didn't miss too much. And I know I've missed something. I always do, right? Unless we're here all day, I'm going to miss something. But I cannot get back up. So don't believe that she's going to say something that I don't have a response for, or to be able to show how it is still reasonable doubt. And remember, you only need one instance. And if you can find that one, then the law says that you must acquit. And because of all of the things I just talked about, for each and every charge that is against my client, all 13, and note that I didn't even individually go through each of those, because the same theory appears on all of them, justification. So because I didn't go through each and every one of them, don't hold that against me, because I really didn't need to, because justification applies to all of them. And if you're finding for the justification, that means that a not guilty on all counts.
Right, exactly, Monica.
Thank you.
Hi, Miss Stanley.
Oh, there's our judge. There's our judge talking to us. So I think there's 16 charges, but don't know. Don't know after his 2-hour talking. Don't know how many charges there are. So we're gonna hear the response tomorrow. And then the verdict. Guys, thank you so much for coming out. I appreciate it. I do. I shall see you all at OJ in a couple minutes, or I'll see you tomorrow. Have a good day. Have a great Saturday. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see